Welcome to U.S. Immigration TV. Now, many people ask, what would happen to their petition if they got married? In this video, I will discuss how marriage could greatly affect the validity of your petition or the waiting time for a visa. Now, first of all, when it comes to marriage, I've often said, if you love them, don't marry them. Now, let's see why. Let's go through some of the various situations so you can see how marriage of the beneficiary, and I mean the beneficiary, could greatly affect a petition. Number one, marriage voids a petition by a lawful permanent resident or LPR green card holder parent of their single son or daughter's case. And that's category F2A or F2B. It does not matter if you were single at the time the petition was filed and then you married later on. You must remain single up until the time you receive your green card, whether you process at the U.S. Embassy or adjust status in the U.S. Now, I have come across many tragic situations where people got married while under petition by an immigrant parent, but claimed that the marriage was secret, or they were promised that the marriage contract would not be recorded. Well, there's no such thing as secret marriages except secret from the parents. And typically, marriage contracts are recorded and they are truly found by the U.S. Embassy. So don't make the excuse or think that just because you're single when the petition's filed, it's okay to get married later on. No. You must remain single all the way through as long as your parent remains an immigrant. Let's talk about another scenario. Number two, an F2B petition could still be valid if the beneficiary marries after the petitioner naturalizes. Now, in some cases, the timing of the parent's naturalization or the child's marriage could affect the validity of the petition. Now, as I already said, if the beneficiary marries while the parent is still a green card holder, the petition's void. It's gone. Marriage voids that petition. However, if the petitioner naturalizes before the child's marriage, in that case, the petition would automatically convert upon the petitioner's naturalization from F2B to F1, which is single child of a U.S. citizen. And then, when the child marries, it would convert from F1 to F3. However, in that situation, the petition remains valid and alive, and the original priority date is intact. If the beneficiary marries before their parent's naturalization, again, the petition is void. So the important thing to note is, on your wedding day, was your parent already a U.S. citizen? If they were, there could still be hope for the petition. It would not be void. If your parent was still an immigrant and naturalized after your wedding day, the petition is going to be void. Now, this scenario leads me to the next rule concerning marriages and petitions. Number three, marriage of the beneficiary converts a petition by a U.S. citizen parent from immediate relative child or F1, single child of citizen, to F3. If a child is petitioned by a U.S. citizen parent as a minor child under 21 years of age, or F1, single adult child, and that child gets married, the petition converts to F3, which is married child of U.S. citizen. The child does retain the original priority date, but now the waiting time for a visa could be at least 10 or 15 additional years. Now, please note, if a person is really anxious to get married and their priority date is just about current as single, it may be faster to first obtain the visa as single, get your green card, come back, and then marry your partner and petition the partner in the F2A category, which is spouse of immigrant, rather than marrying and having the petition convert to F3, where the waiting time might be 10 or more years. I've seen that happen so many times. They should have taken the visa as single and then come back married and do that petition. Now, there are additional situations where marriage could affect the validity of a petition, which will be in my next video. So make sure with this particular video you like, share, and subscribe. And don't forget to watch part 2, which discusses more situations where marriage could affect the validity of the petition. I'm Michael Gurfinkel, and thank you for watching part 1 of this video subject.